Have you ever sat across a heavy mahogany desk, just staring at a stack of papers thicker than a phone book, feeling completely overwhelmed by all the legal jargon?
Oh, absolutely. I mean, it could be a lease agreement, a commercial mortgage, or, the closing documents for your very first home.
Right. And you're just holding the pen, hovering over the signature line, and part of you is praying you aren't, accidentally signing away your firstborn child?
Yeah, it's a remarkably universal feeling, even for seasoned investors, honestly.
Really, even the pros get intimidated.
Oh, for sure. The language of real estate is incredibly dense. It's formal and heavily codified. For the uninitiated, it often feels like, well, a purposeful barrier.
Like a labyrinth designed to just keep you in the dark while you make the biggest financial commitment of your life.
Exactly. But, doesn't have to be that way.
And that is exactly what we are going to change today. Welcome to a new deep dive. Our mission today is to completely demystify this legal labyrinth of property.
We're doing the heavy lifting for you.
Right, by extracting the most crucial, practical knowledge from an incredibly comprehensive source. We're looking at the book Real Estate Law Essentials. Navigate Transactions, Avoid Pitfalls, and Seize Opportunities by Willem Tait.
And Willem Tait brings a really unique perspective to this stuff, too.
He does. He's the author of multiple real estate and personal development books, and he also operates as a highly experienced business consultant.
So he's essentially poured decades of high-stakes, hands-on experience right into this work.
Exactly, so that you can buy, sell, or rent property with absolute confidence. Our goal is to give you cheat codes to avoid getting legally burned. So, okay, let's unpack this.
I love that framing, mainly because Tate makes this brilliant foundational observation right at the start.
It is.
Well, real estate law influences every single aspect of property ownership, right? Yet the vast majority of us just completely ignore the rules of the game until
We've already committed a foul.
exactly, until we are facing a severe penalty. We wait until a massive dispute actually happens to learn how the system works.
Which is pretty much the worst possible time to learn. And according to the source material, the very first thing we have to fundamentally rethink is what it actually means to, own something.
Right, because before you can even begin to negotiate a transaction, you have to know what you're actually acquiring.
And it turns out owning real estate is vastly more complicated than just drawing a line in the dirt and telling your neighbors, everything inside this invisible box is mine.
Oh, it's way more complex. If we look at the historical evolution of property law, the mechanics of ownership are just fascinating.
How so?
Well, for centuries, the guiding principle in the legal system was this really harsh, unforgiving common law doctrine known as caveat emptor.
Which translates to let the buyer beware.
Right. So under strict caveat emptor, the burden of discovery was entirely on you as the buyer.
So if I bought a gorgeous piece of farmland and then 3 days later, a massive hidden sinkhole just swallowed my tractor.
That was entirely your problem?
Oh, wow. So the seller had no responsibility.
Very little. You should have hired someone to inspect for sinkholes. The seller had almost no obligation to disclose hidden defects unless they, actively and fraudulently concealed them from you.
That is wild. But obviously, things have changed, right?
Yeah, thankfully. Over the last century, modern statutory regulations have drastically shifted that landscape to kind of balance the scales.
Right. The book talks about sweeping federal frameworks like the Fair Housing Act.
Exactly. That shifted us away from this system of every person for themselves and established mandatory disclosures and protected rights.
Specifically guarding buyers and tenants against discrimination based on, race, religion, or gender.
Right. The law basically decided that the free market needed guardrails to ensure fundamental fairness.
I always used to think of property ownership like owning a physical object, like, say, owning a laptop.
Okay, how so?
Well, if you own a laptop, you possess total, absolute control over it. You can smash it with a hammer, you can paint it neon pink, you can sell it to a friend.
Sure, yeah.
But Tate's book emphasizes that owning real estate isn't like that at all.
It really isn't. I mean, in law school, the classic framework they teach you in week 1 is that property ownership is not a single right. It's actually a bundle of sticks.
A bundle of sticks.
Yeah. When you buy a house, you aren't just buying the physical wood and brick. You're acquiring a collection of separate, distinct legal rights.
Okay, so each right is a stick.
Right. You get the stick that gives you the right to occupy the space. You get the stick that allows you to sell it. You get the right to lease it out.
But the catch is, I don't get all the sticks in the bundle, do I?
Nope.
Other people actually get to hold on to a few of my sticks.
That is the crucial limitation every property owner must understand. I mean, the government holds onto the stick that allows them to tax you, for instance.
Oh, and they hold the stick of eminent domain,
Right.
Meaning they can force you to sell your land if they need to build a highway through it?
Exactly. Now, the biggest bundle of sticks you as an individual can possibly acquire is called a freehold estate. That indicates you have the maximum level of control for an indefinite period.
But the book breaks freehold down even further. You have fee simple, which sounds like a medieval term, but it just means absolute ownership, the highest form possible.
Right.
But then you have something wild called a life estate.
Oh, a life estate is a fascinating mechanism. It means you own the property and possess almost all the rights, but the timer on your ownership is literally your own heartbeat.
Wait, really? Your heartbeat?
Yeah, you hold the bundle of sticks only for as long as you live. The moment you pass away, the property doesn't go to your heirs through a will. It automatically reverts to a designated beneficiary.
They call that a remainder man, right?
Exactly, a remainder man.
So I could, give a house to my grandmother for her to live in for the rest of her life, and she genuinely owns it. But the second she passes, the legal ownership snaps instantly back to me.
Yep, and it avoids probate court entirely.
That is a really powerful tool for estate planning.
It is, but contrasting that with freehold, we have leasehold ownership. This is when you hold a much smaller bundle of sticks.
So this is like renting an apartment.
Right. You acquire the right to use and occupy a space for a specific limited time frame, but the overarching restrictions are set by the actual owner.
This is the legal foundation for every renter or, any business leasing a commercial storefront.
Exactly. But here's the thing. No matter how many sticks you hold, you carry heavy responsibilities. You can't just ignore the property.
Yeah, you have to pay those property taxes. And you have a legal duty to maintain safe conditions. Like if a delivery driver steps onto your rotting wooden porch and falls through.
You are absolutely liable because you failed in your duty of care.
Yikes.
And those responsibilities also extend to invisible claims on your property, which further prove that ownership is never absolute. The best example of this is an easement.
An easement. Okay, break that down for me.
So an easement is a legally recorded right that allows a third party to use a specific portion of your land for a designated purpose, even though you hold the deed.
Wait, so if I buy the land and a house on it, how is it legal for the municipal utility company to just, show up with a backhoe and dig up my prize-winning rose bushes?
I know it sounds crazy, but it's because when the neighborhood was first subdivided and developed, a utility easement was written right into the deed of the land itself.
Oh, so it's been there since the beginning.
Exactly. The utility company needs the ability to maintain the primary water main that serves the entire street, which just happens to run under your front lawn.
So if they didn't have that invisible claim, society's infrastructure just couldn't function.
Right. You own the land, but you cannot legally build a permanent structure over that utility line, nor can you block them from accessing it.
Which perfectly transitions us into the actual mechanics of acquiring property. Because if there are invisible claims like easements attached to the land, how do we get our hands on that bundle of sticks safely?
Well, you need to look at the anatomy of a bulletproof transaction, because stepping into a legal trap during the purchase phase can ruin you financially.
Right. And the mechanism that protects you from those invisible claims is the title search.
Exactly. Before you finalize any purchase, a title company conducts an exhaustive legal background check on the property's history.
They're scouring public records to ensure the chain of ownership is unbroken and legitimate.
Right. They're basically hunting for ghosts.
Like an undisclosed heir of a previous owner who might suddenly knock on your door and claim they actually own half of your living room.
Or they're looking for unresolved financial encumbrances. Imagine a previous owner remodeled the kitchen 5 years ago but never actually paid the roofing contractor.
Uh-oh. Let me guess. That contractor placed a lien on the house.
Yep, a mechanic's lien.
Yeah.
If you buy that house without a proper title search, that previous owner's debt suddenly becomes your debt.
Wow. So a title search, backed by title insurance, essentially guarantees that the seller actually has the legal authority to transfer the ownership to you, free and clear.
Exactly. And once the title is clear, you move to the real estate contract. And Tait is very clear here. Verbal agreements are a recipe for utter disaster.
Yeah. If you shake hands on a property deal, it is nearly impossible to enforce in court. It absolutely has to be in writing.
But beyond just being on paper, a contract requires 4 specific elements: an offer, an acceptance, legal competence.
Meaning nobody's intoxicated or a minor.
Right, right. And then there's a concept called consideration.
Let's unpack consideration because it tripped me up in the book. I can't just write a legally binding contract that says, I will give you my house for free.
No, you cannot. In contract law, consideration is the mechanism that separates a legally binding agreement from a simple promise of a gift.
So something of actual value must be exchanged between the parties.
Exactly. In real estate, the buyer's consideration is almost always money, and the seller's consideration is the property itself. Without that mutual exchange of value, the court just views it as an unenforceable promise.
Okay, so we have a valid written contract with consideration. Within that document, we find contingency clauses.
Ah, yes, your escape hatches.
Right, you have the inspection contingency, meaning you can walk away if the house is full of termites. You have the financing contingency, in case your lender backs out. And the appraisal contingency.
The appraisal contingency is huge.
I want to highlight the appraisal because the mechanism here is crucial. If I offer $1 million for a house, but the bank sends an appraiser who says, actually, this house is only worth $950,000, what happens?
That is exactly where the appraisal contingency saves you from a massive financial shock. You see, the bank will only lend you money based on their appraised value, not
your offer price.
Right. So if the house appraises for $50,000 less than your offer, you suddenly have a $50,000 shortfall that you would have to pay out of your own pocket in cash.
That's terrifying.
It is. But the appraisal contingency allows you to legally walk away from the contract with your initial deposit fully refunded if the seller refuses to lower the price to match the appraisal.
That is a massive safety net. But, it makes me wonder, if I'm a buyer and these contingencies protect my money, why wouldn't I just throw in every single contingency imaginable?
You'd think so, right?
Yeah. Why not make the contract entirely risk-free for myself?
Well, it comes down to the strategic reality of a competitive market. A contract is a negotiation of risk.
So if I load up an offer with 6 different contingencies demanding perfect inspections, extended financing windows, and a clause saying I only buy this house if my current house sells first,
your offer looks incredibly weak and precarious to the seller. You're basically asking them to take on all the risk of the deal falling apart.
Ah, I see. So a seller will frequently reject a highly contingent offer in favor of a cleaner offer.
Oh, all the time. Even if that cleaner offer is for slightly less money, simply because the cleaner offer is a sure thing, you have to balance protecting your downside with actually winning the bid.
And Chapter 9 of Tait's book highlights how people ruin this balance. Buyers get desperate in hot markets and waive their home inspection entirely to look like a clean offer.
Which is so dangerous.
Right. Only to move in and discover the foundation is crumbling.
It happens all the time. The buyer assumes the risk to win the bid, and the unseen physical reality of the property bankrupts them.
Okay, so let's assume you strike the perfect balance. You negotiate the contingencies, you close the deal, the property is legally yours.
Congratulations.
Now, you decide you want to tear down the existing house and build a 4-story apartment building, or maybe a commercial warehouse.
Uh-oh.
Right. Before you even break ground, the city steps in and shuts you down. Why? Because the transaction is only half the battle.
Exactly. The other half is governed by the invisible boundaries of zoning and land use.
This is a profound shift in how we view property. Zoning laws dictate that your physical ownership of the land is entirely subordinate to what the surrounding community allows you to do with it.
It really is. I mean, you own it, but you can't just do whatever you want.
I think of buying property like buying a blank canvas at an art store. You own the canvas, you can take it home.
Mm.
But zoning laws are the municipal rules dictating exactly what colors of paint you are legally allowed to apply to it.
That's a great analogy.
Right. If the neighborhood council has designated your street as a pastel-only zone, you do not have the right to paint your canvas neon green.
That captures the dynamic perfectly. And the legal authority to dictate your paint colors comes from the government's inherent police power.
Police power. Like cops.
Well, no, it's their authority to regulate behavior to protect public health, safety, and general welfare. The modern framework for this was actually established by the Standard State Zoning Enabling Act in the 1920s.
But the book mentions it was fiercely contested, right?
But very fiercely. Property owners argued it was a direct violation of their constitutional rights. This led to a massive, landmark 1926 Supreme Court case, Euclid v. Ambler Realty Co.
Which is arguably one of the most important cases in American property law. What was the core conflict there?
Well, you have to picture the reality of the 1920s. Rapid industrialization meant you had massive polluting factories being built directly adjacent to residential neighborhoods.
Right. Terrible for health.
Exactly.
Yeah.
So Ambler Realty owned land they wanted to use for heavy industry, but the village of Euclid zoned it to prevent that, severely dropping the land's value.
So the Supreme Court had to decide, can the government legally tell you what you can't build on your own land?
And the court ruled yes. They determined that separating industrial smog, noise, and heavy traffic from residential homes was a valid constitutional use of police power to protect the public welfare.
Wow. And that decision birthed modern zoning.
It did. So that gives us the broad classifications we see today. You have residential zoning, which doesn't just mean houses go here.
Right. It dictates the precise mechanics, minimum lot sizes, how many feet your house must be set back from the sidewalk, and maximum building heights.
Then you have commercial zoning for retail, which heavily regulates things like the required number of parking spaces based on the square footage of the store.
And industrial zoning focuses on mitigating environmental impacts, mandating noise buffers, things like that.
Yep. And beyond municipal zoning, you have to navigate private land use restrictions.
Oh, like HOAs, homeowners associations.
Exactly. If you purchase a home governed by an HOA, you agree to a contract of covenants.
And these private rules can be astonishingly strict. They dictate everything from the exact shade of beige you can paint your front door to the type of shingles on your roof.
Even prohibiting you from parking a commercial work truck in your own driveway.
That is wild. But let's look at a clash of rules. Say I own a small, bustling auto repair shop that has been on a specific corner for 40 years.
Okay.
Then the city suddenly updates their master plan and rezones my entire street to be strictly residential. Are they going to force me to tear down my garage and build a house?
No, thankfully the legal mechanism protects you there. Your auto shop would be classified as a non-conforming use.
Non-conforming use.
Right. Because your business existed legally before the zoning rule changed, you are grandfathered in. You have the legal right to continue operating.
Okay, that makes sense.
However, if your auto shop burns down, the city likely will not allow you to rebuild it because the new rules now apply to any new construction.
Oh, interesting. And what if it's the reverse? I buy an empty residential lot and I really want to build a small coffee shop there. The zoning says no. Am I just out of luck, or is there a way to fight it?
You can petition for a zoning variance. A variance is a formal legal request to the local zoning board asking for an exception to the established rule.
But I'm guessing it is not easy.
Not at all. You generally have to prove that the strict, literal application of the zoning law creates an undue, unnecessary hardship for you that is unique to your specific piece of land.
Sounds like a highly subjective negotiated process.
It absolutely is.
Okay, so to afford this highly regulated canvas, whether it's residential or commercial, you almost certainly had to leverage capital. You borrowed a ton of money from a lender, or you planned to lease the property out to generate revenue.
Which opens up an entirely new dimension of financial and rental laws. Let's follow the money.
The financing structure dictates your immediate risk. When you secure a mortgage, you are typically choosing between a fixed-rate mortgage, where your interest rate is locked in for 30 years.
Providing absolute predictability.
Right. And the alternative is an adjustable rate mortgage, or ARM, where the rate fluctuates based on macroeconomic conditions after an initial fixed period.
And Tait's book highlights a massive pitfall for first-time buyers here regarding their actual monthly obligation. People think their mortgage payment is just paying back the money they borrowed.
But they forget about the T and the I in a PII page.
Exactly. PITI stands for principal, interest, taxes, and insurance.
The principal and interest go to the lender for the loan itself. But the lender also requires you to pay your annual property taxes and homeowner's insurance in monthly installments into an escrow account.
Right. And the lender does this to protect their collateral. If your house burns down and you don't have insurance, the bank loses their investment.
So a common reason new buyers default is they only budget for the principal and interest, and the addition of taxes and insurance suddenly makes the true monthly cost entirely unaffordable.
Exactly. And to secure that loan, the bank uses a LIN. A mortgage is a voluntary LIN hell. You willingly signed a contract saying, if I don't pay you back, you can take my house.
But involuntary LINs are the hidden torpedoes of real estate.
Oh, they are devastating. They're placed against your property without your consent to satisfy a debt.
So if you fail to pay your property taxes, the government places a tax lien on the house.
Right, or if you lose a civil lawsuit and refuse to pay the judgment, a judge can attach a judgment lien to your property.
And functionally, a lien freezes the asset. You cannot legally sell or refinance that property until the debt attached to the lien is fully satisfied and cleared from the title.
Exactly. Now, if you start making your PITI payments entirely, you trigger the foreclosure process.
But it's important to understand the mechanics here, right?
Yeah.
The bank doesn't just show up and change the locks the day you miss a payment.
No, no, it is a protracted legal procedure. It begins with a formal notice of default, giving you a legal window to cure the debt and catch up.
And if you fail, the property eventually goes to a public foreclosure auction.
But Tate emphasizes that foreclosure is the worst-case scenario for everyone involved, including the bank. Banks do not want to manage real estate. They want to manage money.
Therefore, alternatives exist.
Exactly. You can negotiate a loan modification to extend the term and lower the payment. Or if the property is worth less than what you owe, you can attempt a short sale.
So a short sale is a mechanism where you find a buyer and you essentially plead with your lender to accept the proceeds of the sale as full satisfaction of the debt.
Right, forcing the bank to take a financial loss just to avoid the grueling expense of a foreclosure.
Let's shift from banks to humans. Because if you decide to hold on to the property and lease it out to pay that mortgage, you are entering arguably the most emotionally charged, highly litigated arena of real estate law.
Landlord-tenant relations.
Yes. The friction here is structural. You have two parties with competing interests occupying the exact same physical space.
Right. The tenant possesses a fundamental legal right to habitability. The landlord is legally mandated to provide a safe environment with working plumbing, heat, and structural integrity.
And the tenant also holds a right to privacy. A landlord cannot simply unlock the door and walk in unannounced.
Conversely, the landlord retains the right to payment and the legal right to evict if the tenant violates the terms of the agreement.
Let me push back on this for a second, though. If federal and state laws already strictly dictate all these rules about habitability, safety, and eviction procedures, isn't a lease just a glorified, oversized receipt for rent?
It's tempting to think that, but it's a very dangerous misconception. The state law only provides the absolute minimum baseline.
So what does the lease actually do?
The lease agreement itself acts as a hyper-localized constitution specifically governing your property. The lease dictates the microscopic mechanics of the relationship.
Oh, like who is financially responsible if the washing machine breaks?
Exactly. What is the exact penalty if rent is delivered 4 days late? Is the tenant allowed to run a small e-commerce business out of the spare bedroom?
The state law doesn't answer those questions. The lease does.
Right. It is a binding framework that prevents ambiguity.
And yet ambiguity still happens. Chapter 9 outlines brutal mistakes here. Landlords who fail to adequately screen tenants, skipping comprehensive background and credit checks, just invite chaos into their investments.
And on the flip side, tenants who casually skip the initial move-in inspection document often find themselves legally liable for repairing damage that was already present when they moved in.
Simply because they have no proof otherwise.
Which brings us to a harsh reality. Despite having an ironclad lease, a pristine title search, and perfect zoning compliance, humans are messy, subjective creatures.
Disputes are an absolute inevitability in real estate. How we resolve those disputes is a critical part of the law.
Yeah. When the inevitable happens, you basically have an escalating ladder of 3 resolution paths.
The first rung is mediation. This is entirely collaborative. You and your neighbor sit down with a neutral third party who facilitates a conversation to help you find a mutual compromise.
It is relatively inexpensive, and most importantly, it preserves the relationship.
If that fails, you step up to arbitration. This introduces a higher level of formality. You present your case to a neutral expert, often a retired real estate attorney or judge, who acts as a private adjudicator.
They review the facts and hand down a decision. It is far faster and more private than the public court system, but in most cases, the arbitrator's decision is legally binding.
You cannot simply ignore it if you lose.
Nope. And the final rung is litigation, the traditional courtroom approach. It is intensely formal, entirely public, and financially agonizing.
You really only want to unleash litigation if the financial stakes are astronomical and every other path is completely crumbled.
However, looking toward the future, the way we handle transactions and avoid these disputes entirely is undergoing a massive technological revolution. The legal frameworks are struggling to keep up with the digital reality.
This is where the landscape gets truly futuristic.
Ugh.
We are seeing the integration of blockchain and smart contracts into property transfers.
The theory is that title histories could be placed on a decentralized, unalterable digital ledger.
Making fraud virtually impossible and title searches instantaneous.
Exactly. We also have artificial intelligence processing massive urban datasets to predict neighborhood property values and instantly flag missing clauses in 50-page commercial leases.
And virtual reality is allowing global investors to take hyper-realistic spatial tours of properties thousands of miles away, purchasing them sight unseen.
These technologies are fundamentally compressing the speed of the industry and injecting unprecedented transparency into the market.
But let me ask you this, because we follow this thread to its logical conclusion.
Okay, go ahead.
If a smart contract on a blockchain can automatically execute the transfer of a deed the exact millisecond the cryptocurrency hits the seller's wallet, will we even need real estate lawyers or title companies in 10 years? Won't the algorithm just govern the entire transaction?
It is a profound question. The administrative friction, the manual verifying of records, the physical paper pushing, the escrow delays that will absolutely be automated away by algorithms.
That's the human element.
The human element of real estate is inescapable. An algorithm cannot negotiate the subjective, creative financing terms of a complex commercial deal.
And more importantly, an algorithm cannot resolve the physical realities of land ownership.
Exactly. When a 100-year-old oak tree falls on a shared property line and destroys a fence, or when a landlord and tenant disagree on what constitutes normal wear and tear, subjective human judgment is required.
So the role of legal expertise will shift away from administration and entirely into high-level strategic negotiation and dispute resolution.
That is exactly where we are heading.
That makes perfect sense. The physical world will always require human referees. And speaking of the physical world, technology isn't the only frontier. Sustainability is reshaping property law.
Oh, massively. We are witnessing the rapid adoption of green building standards like AD certification, where developers must meet incredibly strict energy efficiency and material criteria to get approval.
Governments are weaving renewable energy incentives directly into the tax code.
And we are seeing the rise of climate resilience laws. Municipalities are actively rewriting zoning codes to dictate exactly how, or even if, you can build in expanding floodplains or areas increasingly prone to seasonal wildfires.
Environmental impact is no longer a fringe consideration. It is becoming the central pillar of modern real estate law.
If we pull all of these threads together, from the historical shift away from caveat emptor to the digital horizon of smart contracts, the core takeaway from Willem Tait's book becomes incredibly clear.
Real estate law is not just a frustrating list of restrictions designed to slow down your ambitions.
No, it is a highly evolved, powerful toolkit. It is a system designed to structure risk.
Whether you are signing a standard one-year apartment lease or you are syndicating capital to purchase a 50-unit commercial complex, proactive due diligence is your absolute best defense.
You don't need to pass the bar exam, but you must understand the underlying mechanics of the game you are playing.
You have to know what sticks are in your bundle. And that brings us to a final provocative thought for you to ponder long after you've finished listening today.
Right.
As virtual reality, artificial intelligence, and blockchain technology make the act of buying property increasingly instantaneous, frictionless, and completely borderless, will our traditional hyper-local zoning laws and bitter neighborhood HOA disputes survive the clash with a truly global digital real estate economy?
When capital moves at the speed of light, how does it interact with a town council that only meets once a month?
It is a massive structural tension. Watching how the legal system adapts to that global pressure will define the next era of property ownership.
We will leave you to chew on that.
Before we wrap up today, if you want to dive deeper into this incredible resource and master the mechanics of property yourself, we have a quick request. Please contact your local library. You can do it right through their website or app, and ask them to list Real Estate Law Essentials by Willem Tait for free so your community can access it.
It's a great way to support local access.
Definitely. Or if you want to support Willem directly and add it to your own shelf, you can buy his books at Walmart, Amazon, Apple, and many other major retailers. Also, be sure to connect with Willem on his socials, which we have linked right in the description of this deep dive. Thank you so much for joining us for this episode, and we will see you in the next one.